At 11:35 on July 15th of 2025, Andres Caceres was released on bond for offenses of felony hit and run and misdemeanor reckless driving. He had dozens of prior arrests. That was on July 15th. He was released on a no-cash bond. 3 days later, he was at Fair Oaks Mall in Fairfax County, where a horrific video showed him attempting to abduct a 3-year-old girl at that mall. At that moment, once his criminal history became public, the public was rightly outraged. Effective silence from the Fairfax County Commonwealth's Attorney's Office. Shortly thereafter, the governor asked our office of the Attorney General to both not just investigate this matter, but look at the entire pattern of failure by the Fairfax Commonwealth's Attorney's Office, their failure in protecting victims, their failure in protecting law-abiding citizens and the surrounding populations. But the reality is if you ever talk to victims of crime, one of their great fears is that they will just become a number, a statistic. The reality is their lives have been forever changed. There is a date in their life where there is a before and after. For some of them, they will always have an empty chair at every Thanksgiving, holiday celebration, and birthday celebration. And their biggest fear is to be ignored, to be treated as just a statistic. Tragically, they are real human beings. They have been through an unbelievable journey of pain and loss. Their names are Rachel and Amber and Cody and Laura, Emily, Danita, Tammy, Leslie, Kara, Janine, Sherry, Denise, Jennifer. These are individuals that are our friends and our neighbors. We work alongside them, and oftentimes they carry with them a pain that stays with them the rest of their lives. I've said before that sunlight is the best disinfectant. It's a beautiful day here in the Commonwealth, and I think, figuratively speaking, what we wanted to show is sunlight on perhaps one of the most horrific patterns of both incompetency and ignoring victims and ignoring the safety of its citizens that we have seen in any Commonwealth's Attorney's Office in the history of Virginia. The 1 million residents in Fairfax County deserve better than what they are getting, because no Virginian should be looking over their shoulder in fear. Today is September 26, 2021. It is the 4th anniversary of the murder of Regina Elizabeth Redmond. Her mother could not join us today because she's remembering her daughter today. She died 4 years ago after being brutally attacked by her husband. She was first attacked by her husband July of 2021, where he strangled her to the point that she had to seek medical attention. The police became involved. Her husband always said that if she talked to the police, he would kill her. They went to court. Regina's husband was released on an unsecured bond with an ankle monitor, and he was simply able to walk free and told to return to court. Regina went home to her home on the 19th of September, where he brutally attacked her with a hammer, beating her over and over again, and then he called the police and bragged that he had just killed his wife. She died 1 week later on September 26. Regina's mother, Melanie, wrote me a letter outlining her pain leading up to this day. And she ended her letter with the following line: "A mother should feel her child's first heartbeat, never their last. It is unnatural for a parent to have to bury their own child." This story is more than dozens and dozens, if not hundreds of instances where the Fairfax County Commonwealth's Attorney's Office, Steve Descano, has refused to do his job. And as a result of his incompetence and his failure to do his job, people have been hurt or killed. I want to be clear. This is not a failure of policy. This is a policy of abject failure. Over the course of the last month, the Office of the Attorney General has worked and compiled a report that has been released now to the public. And this investigative, comprehensive report exposes this alarming pattern of both misconduct, neglect of victims' rights, constitutional violations, and dangerous prosecutorial policies that have been found within the Fairfax Commonwealth's Attorney's Office. It is a violation of both incompetency, multiple findings of Brady violations where they have failed to turn over exculpatory evidence, therefore resulting cases being dropped, improper plea agreements where they ignored the pleas of their victims, prosecutorial incompetence where members of their own office are saying we are not prepared to handle these cases, and then enacting unlawful and unconstitutional policies where they have decided to suspend entire categories of the law, superseding his judgment over the judgment of 140 members of the General Assembly and the governors. I would note that Article 1, Section 8 of the Bill of Rights of the Virginia Constitution says, and I quote, "In all criminal prosecutions, the victim shall be afforded fairness, dignity, and respect by the officers, employees, and agents of the Commonwealth and its political subdivisions." And the General Assembly has further enacted the Crime Victim and Witness Rights Act, which lays out that victims' rights cannot be ignored or silenced, that they guarantee certain procedural rights, including advance notice of court agreements and consultation on all proposed plea agreements. We've also seen where Steve Descano has decided to provide extra benefits to those that are here illegally in criminal proceedings that are never allowed to citizens that are also the victims of criminal proceedings. Wilmer Osme Ramos Giron, a Guatemalan national, was deported from the United States both in 2012 and 2020. In January of 2025, Ramos choked his ex-wife during an argument and brandished a knife. The Fairfax Commonwealth's attorney requires prosecutors in all of their cases to, quote, consider immigration consequences when offering plea agreements, and urges prosecutors to attempt to avoid immigration consequences whenever possible. That is not a benefit allowed to a citizen that is accused of a crime. It is a benefit he allows to non-citizens in this country. He allowed, in this case, this individual to plead guilty to lesser charges of assault and battery. They represented to the court in this case that the agreement achieved the outcomes the victim wanted. But then the victim came out and denied that the Fairfax Commonwealth's attorneys claim that it was actually what they wanted. This violated both their victims' rights. It violates the Virginia Constitution, Article 1, Section 8A, that they be treated with fairness, dignity, and respect. Ryan Durante met a 14-year-old girl online. He said in his text messages with this 14-year-old girl, "I kill people for fun," in graphic sexual contact. The victim noted that they treated her more like the perpetrator rather than the victim of the crime. And over their wishes, they offered this perpetrator a plea of guilt. You look at Commonwealth Oscar Salvador, who ignored the victim opposition in a horrific case. This was a case where this individual, and we have some victims here, so I'm going to somewhat sanitize what I say because out of respect for them and what they've lived through. But let's just say that what this individual did to these children between the ages of 5 or 10, he was actually eligible for a life sentence. But this office decided a life sentence was too harsh. So they'd walk down to a plea deal in which he would be a maximum sentence of no more than 30 years, in which he'd be actually eligible for geriatric parole. The judge referred to Salvador as the worst kind of predator and told the victim that she had been victimized not only by her perpetrator, but by the Commonwealth's attorney. And I quote, and this is what the judge told the victim from the bench, "Your government has failed you." He is currently slated to be released from prison in just 8 years. A man who is eligible for life in prison for repeatedly sexually assaulting and raping children as young as 5 will be eligible for release in just 8 years. The victim fathers described it this way: the Fairfax Commonwealth Attorney's Office put more importance on the defendants than they do the victims. They leave the victims on the side. That's just the way we feel. We discovered multiple violations of what's called Brady material. That is, when you're accused of a crime in this country, you are allowed, as part of your defense, any and all exculpatory evidence. It is considered one of the bright line rules you have as a prosecutor. Failure to provide this Brady material is considered a violation of due process under the U.S. Constitution, and cases collapse as a result. We saw multiple instances where they failed to provide the exculpatory evidence as required under our Constitution. You have Kelvin Gonzalez, who they failed to provide any and all exculpatory, some of the key exculpatory evidence. As a result, they could not proceed further with the case. As a result, the Commonwealth, as the court noted, quote, buried its head in the sand. They decided not to provide it. They never called the witness. They admonished publicly their violation. Gonzalez then had his charges dropped. He later was picked up and arrested for selling narcotics. You have a case of Ronnie Reel. Ronnie Reel is truly one of the worst of human beings. And in this case, Amber Reel, who did everything right as a mom, who came forward, because of their incompetency, will not seek justice, will not see justice for what happened. And out of respect, I am not going to go into the details. But I will share a little bit what she has said on this matter. The prosecution said this was an open case as we had 2 confessions and a DNA evidence. Not once was the prosecution in contact with me or my lawyer during the process. The Friday before the trial, I received a call, not from the prosecutor, but from the support people, that there may be an issue as the prosecution failed to file the motion of discovery. And because of the major failure to file all of the necessary evidence and testimony, he would not be allowed in trial. Amber has lived in agony of knowing she tried to play by the rules to do the right thing. And because of the incompetence of this office, she will not see justice for what happened to her child. Robert Reynolds was charged with multiple rapes of an 11-year-old girl between 1983 and 1986. They also failed to file the necessary evidence in a timely manner. They dismissed the charge with prejudice because of the Commonwealth's attorney's discovery violation, meaning that charge can never be refiled. The victim gave the following statement to our office. The Commonwealth's attorney's office under Steve Descano told me my voice cannot be heard because of political reasons. In that moment, my hope was shattered. I cried and cried, unable to understand why the judicial system had failed me yet again. They had 3 years to submit discovery, and yet I was simply shuffled between Commonwealth's attorney. The worst part is that she told me their incompetence was political. We found multiple improper plea agreements, as has been noted, where they choose to ignore the victims. They seek plea agreements so lenient that the court rejects them out of hand. They were rejected due to their offensiveness to the rule of law and the administrative of justice. I think of Commonwealth versus Hiram Rodriguez. Rodriguez was an illegal alien from Honduras who broke into the victim's home in the middle of the night, entered the bedroom where the mother and the 4-year-old child was asleep, and attempted to abduct the child. Blessedly, the defendant only made it as far as the living room, where the child's screaming apparently had him drop the child. There was overwhelming DNA evidence and a fingerprint there. He could have been punished up to by maximum of life in prison, and burglary was itself a 20-year prison sentence. In circuit court, the Commonwealth's attorney took what was possibly a life sentence and reduced it to a maximum of no more than 2 years. And they attempted to cap his actual sentence as no more than 2 years of active incarceration. And the judge noted in rejecting this plea deal, this is every parent's worst nightmare. The court concluded, a criminal justice system that cannot protect a 4-year-old child in such circumstances is a failure. Ladies and gentlemen, that is a failure solely at the feet of Steve Descano. You could see cases like Brian Rojas, who took a machete after brutally wounding and murdering a cat, took a machete and tried to attack a police officer, nearly striking him. They reduced the charge simply to an assault and battery against law enforcement. They also rejected the proposed plea, partly because of the utterly horrific, gruesome, and devastating and lethal wounds that killed the cat and also could have taken the officer's life. You have Commonwealth versus Ray Emperado, who's charged with 4 counts of raping a child under the age of 13. Each was punishable to a mandatory minimum life sentence. The Fairfax Commonwealth's Attorney's Office agreed they would only serve 3 years in prison. Multiple charges, each with a life sentence. 3 years in prison. This is a defendant that by the court found expressed no remorse or acceptance, and actually the defendant in this horrific case blamed the child victim for the commission. You labor on top of that, the prosecutorial incompetence. We have written email from a Fairfax Assistant Commonwealth's attorney begging their supervisors for help, that they recognized they were not competent to prosecute these cases. And I quote, "I've realized that I am both incredibly overwhelmed and completely unprepared to handle 48 of the worst crimes in our society. I'm wandering around blind here, attempting to figure out how to handle 48 sex cases with very, very little input. My experience is traffic, misdemeanors, guns, drugs, and financial crimes, and other low and mid-level felonies. Sex crimes are cases I have never dealt with. I fear I'll mess up in a way that could cause me to lose my license." Well, we saw that as it has been illustrated repeatedly. And we get to Richard Cox. Richard Cox is an example of what happens when a justice system decides that they'd rather act like a social worker than be a prosecutor, and allowed him back on our streets. He was a Tier 3 convicted sex offender who frequented Fairfax and Arlington County community recreation centers. He would enter those recreation centers and regularly undress and shower in women's locker rooms. He is a biological male. He has been a registered sex offender since the 1990s. He had previously been convicted of taking indecent liberties with a child, and he was required to register as a sex offender. In 2006, he was convicted of possession of child pornography, because in 2006, he was then found loitering in the children's section of a library with a laptop computer. The General Assembly decided to change the law. The law allowed anybody to change the sex on their state-issued driver's license to whatever their gender identity is. So even though Richard Cox is a biological male, he suddenly had a state-issued driver's license. This was a law that went into effect under Governor Northam. Thank you. Hope I don't get stung out here. This was a law that went into effect under Governor Northam that allowed him, with a state-issued driver's license, to suddenly identify as a female and go into female safe spaces and in their locker rooms. We know that he absconded from probation supervision. He essentially couldn't even provide his proper address. Despite all of this, despite the fact that he had been found not being in touch with his probation officer, not even providing an up-to-date address, removing his GPS tracker bracelet, the Fairfax Commonwealth's Attorney's Office null pros 2 of those probation violation charges, and he was simply allowed to plead guilty to 1 misdemeanor count of failing to register as a sex offender. Well, what happened? Well, what happened is he continued to go into women's safe spaces. And in July of 2024, from 2023 to 2024, he resumed exposing himself.
There's a bug.
And
On the left.
was it a bee?
It's Japanese land.
Oh, okay. Well, they're friendly. On June 6, 2024, he went into Planet Fitness, where again he used his state-issued driver's license to gain access, claiming that he was transgendered, and accusing the victims that complained about him walking around as a biological male, fully nude in the locker room as having, quote, anti-trans discrimination. The Fairfax Commonwealth Attorney's Office declined to participate in the prosecution of Cox, and the indecent exposure charge was later dismissed. Now, I have to note, the Fairfax Planet Fitness is located in the same building as the Jolly Yolly Kids Indoor Playground. Cox is prohibited from loitering within 100 feet of any place operating as a child daycare program. He should be prosecuted for a Class 6 felony by virtue of his presence within 100 feet of the child daycare playground. No charges to date have been filed. As a result, he remained on the street. And as a result, we now know he went to Washington Liberty High School in Arlington. We now know, just from recent reports, that he kept on his phone the schedule of the girls' swim team. So he could literally travel where they were and walk into their safe places. He was issued a pool pass under the name of Ricky Cox, and he visited these high schools 8 times in October and in November. And a mother of her 5-year-old child, I'm not going to get in, again, you all can read the report in very, very graphic detail what he was doing and how he was violating. To date, he still, despite multiple exposure incidents, the Fairfax County Commonwealth Attorney's Office has refused to initiate proceedings against Cox for all of these good behavior violations. He has not been charged or arrested with any sex offenses-related felony offenses in Fairfax. A Commonwealth attorney in Virginia is charged, and they take a very similar oath that I did as Attorney General, to faithfully execute the laws of the state of Virginia. Steve Descano is failing to do that. In fact, all Article 1, Section 7 of the Bill of Rights has indicated to follow the laws, but they are not allowed to suspend those laws. The Supreme Court of Virginia have said unlawful suspension of laws occurs when an executive sets aside a generally applicable rule of law based solely upon his disagreement with that law. That is Supreme Court holding. Steve Descano has decided to violate Article 1, Section 7 of the law, the suspension clause, and ignore whole categories of law because he disagreed with the judgment of the General Assembly. For example, he has instructed all of his prosecutors to strike any and all mandatory minimums and plea agreements, to endeavor to negotiate remaining mandatory minimums that still are in effect in Virginia law today. But Descano lacks that authority to set aside as a matter of policy in every case any and all mandatory minimum laws. The judgment of the General Assembly is that certain crimes are so dangerous and heinous that they deserve only one punishment that can be reduced or modified. Descano lacks the authority to act as a legislator and unilaterally decide that the General Assembly was wrong to pass mandatory minimum sentences for crimes such as child rape and repeat drug dealing. Descano's refusal to enforce mandatory minimum sentence laws is indeed a violation of Article 1, Section 7 of the Virginia Constitution, which prohibits the suspension of any law without the consent of the General Assembly. He has also said he will not charge any larceny-related crime of $1,500 or less. He has therefore essentially legalized theft for any item worth $1,500 or less, another violation of Article 1, Section 7. He's also ignored Virginia law by ignoring the requirements for cash bail for repeat felons. Current Virginia law requires any person arrested for a felony who's previously been convicted of a felony or who's on probation on bond for another unrelated arrest in any jurisdiction may be released only on a secured bond. He has decided to go and treat Fairfax as a no-cash bail jurisdiction in violation of the clear direction of the Virginia Code. He has asked his prosecutors never to seek cash bond. He's obviously entitled to his own opinion. He's not entitled to ignore Virginia law. As a result of what we have noted by Steve Descano, what we have seen is the gross incompetency. I'm referring this matter to the U.S. Department of Justice for further civil or criminal investigation of whether Fairfax Commonwealth Attorney's Office conduct has engaged in a pattern of practice in denying U.S. citizens the same rights, privileges, and immunities as illegal aliens in charging decisions and plea agreements. That is in violation not just of due process, it is also in violation of a 1996 law passed by Bill Clinton, signed into law by Bill Clinton, called the Illegal Immigration Reform and Immigrant Responsibility Act, which prohibits states from providing benefits to illegal aliens that are denied to citizens. By saying to prosecutors, you are to consider an individual's immigration status and giving them sweetheart plea deals that you would not give to a normal U.S. citizen, you're in violation of that law and the 14th Amendment Equal Protection Clause. We're also referring him for considering harboring or shielding from detection or attempting to conceal from the detection any illegal alien in violation of 8 U.S. Code 1324. In addition, we are also recommending to the Virginia Assembly several reforms that they can enact during this next session to make sure that rogue prosecutors like Steve Descano are held responsible, but also to protect victims. A prior law that I previously advocated for that has died on party line votes would help protect minors from sex crimes by expanding the prosecutorial discretion by the Office of the Attorney General, because victims deserve second chances. When a victim is having a local prosecutor, either through incompetency or through policy, refusing to protect victims, particularly those children that are the victims of sex crimes, the Office of the Attorney General should be allowed to come in with concurrent jurisdiction and prosecute to the fullest extent of the law. I'm asking the General Assembly to resume the presumption against bail for any violent offense listed in Virginia Code 17.1-805 to protect the safety of the community during the pendency of the criminal case. And I'm asking them to work with me to establish a working group on how we can strengthen our victims' rights provision within our Constitution. I want to be clear. So many of these cases that I've mentioned today are a fraction. There are cases from victims that are standing by for me that I was not able to get to out of respect for our time and candidly the weather and perhaps the bugs. But I want to be clear, each one of the people behind me represents the face of a victim that has had their lives forever changed. Each one of these victims thought the justice system was going to work for them, and I can't tell you their sense of betrayal, utter betrayal, when they realized the justice system failed them and in some cases worked against them. Justice is not optional. Our laws are not suggestions. Fairfax Commonwealth's attorney Steve Descano has betrayed the rule of law and the very, very people he has sworn to protect by turning prosecutorial discretion into deliberate, weaponized incompetence. The oath we as prosecutors take to uphold the law and protect victims is sacred. It demands courage, integrity, and perseverance in the pursuit of justice. It, at minimum, means treating victims with a fairness and dignity and respect. That's also in the law, but it also is a basic test of human decency. And it means enforcing the laws passed by the people's elected representatives. When any one prosecutor refuses to do this, victims are indeed denied justice. The public loses faith in the very system that's meant to protect them. What Steve Descano is doing in Fairfax County is dangerous and wrong, and it cannot continue. This agenda is not a one-off policy. It's an approach that puts criminals first and victims last, and it's intentionally designed to fail Virginians. And so yet again, once again, I'm asking Steve Descano to resign, because it is a shame that these individuals behind me have never had a chance to meet with Steve Descano personally to express their frustrations. The vast majority of these people have never encountered him. And the fact that they have to go to their state attorney general to have their voices heard is a reflection on this weaponized incompetence that Steve Descano has turned the Fairfax Commonwealth's Attorney's Office into. Stop being a social worker, stop being a criminal defense attorney, and start being a prosecutor. And if you're not willing to do your job, resign so somebody else will do it for you. Thank you all. And so I'm happy to answer questions. The victims behind me, I know they're willing to answer some questions as well. And I want to also thank them. They've been incredibly noble and brave to be willing to stand and relive some of the worst moments and the tragedies they've undergone in their lives.
Mr. A.G., you mentioned that you're referring some of this to DOJ. Do you intend to panel a special grand jury, or are there state code sections?
No, that would be DOJ. We would refer this to DOJ.